Hi, gang. Welcome to class 3 of our fundamentals course. Today, we're going to be really working on facts and issues. And the other thing that we're going to be working on is case citation. But this part of our lecture is going to be on facts and issues. So we're in Hamey's chapter 2, and then we have 2 chapters in Stasky. But when you're reading cases, or when you're maybe even more likely in your career, people come up with a story, and there are different kind of facts that you need to explore when you're talking about them. Okay, so there's relevant facts, which are really the essential facts that you need to determine whether or not you have a good case, or whether or not the elements of your cause of action are satisfied. Then you have explanatory facts, which are helpful to, give a greater context of the factual situation. And then you have irrelevant facts. So if you go to like page, irrelevant or legally unimportant facts. So the relevant facts are essential. When we talk more in Stasky, we'll talk about them as key facts. They will be important for you both legally and factually. So if you want to know what a relevant fact is, if the fact were different, then the result of the case would be different. Your explanatory facts, they give you the context, tell you, what was happening around the factual situation. And then legally unimportant facts, was the car black or blue when in a car accident, things like that. They do not significantly alter the situation. So when you are coming in, a client is coming in, or you're looking at a report of a client interview, it's up to you kind of to sort out of the enormous amount of facts that they might give you where they actually fall. A client itself, he or herself, will have facts that they think are important, potential motivations of the other party, this is why they did this because they hate me, or they, the manager had it in for me, or whatever it is. You need to be able to sort those things out when you're trying to figure out what, just the facts, ma'am, if you think of those old cop TV shows of yore. Okay, so page 22 of Hamey's. There's, this is kind of a fun one. Let me get to my Hamey's. Is it here? Here we go. Okay, so we have an example. So we get these situational facts. Maybe it's from a police report, maybe it's from a client statement, maybe it's from an insurance report or something like that. So someone was driving 40 miles per hour, and then someone who was driving faster ran into the back of the vehicle. This is the type of vehicle it was. Did not notice. One was talking on a cell phone. One was coming from a doctor's appointment, took a sedative, stress lately, serious damage, injury, couldn't get to her job, and she's an exotic dancer, and blah, 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 blah. Okay, so we're sorting the facts. Our relevant facts, or maybe our key facts, if we want to call them that. Okay, Emerson was driving when he had taken a sedative. That's super relevant. It goes to negligence, right? Same thing here, exceeding a safe driving speed under the conditions. This is just like a fact. This is what happened. Emerson rear-ended Rima's vehicle. There were damages and there were lost wages, right? So that goes to damages here. Explanatory facts. So it's giving us the context around what happened. He was hurrying. He was talking on a cell phone. He was coming to the coming from the doctor. he was going faster than she was, and he wasn't even noticing. Didn't see brake lights. I think that's actually, I would think, whatever. That would be a relevant fact too. Okay, other things that are not important for your legal issues, what they do for a living, the color of the car. So those are also things you might want to, when you're sorting out your facts, like, oh, what's important, what's not important, what do I need to use in my case. Okay. So when you're looking at cases, so this is my client's case, right? This I don't know who I represent. Maybe I represent Rema. Okay. And then I'm researching. And when I'm researching, I'm trying to find other cases that are similar to mine to find out what legal standard applies. So, what I want to do when I'm looking at a case, I want to look at the facts of my case, as we've discussed above, and see where they're similar to the case that I'm reading, the legal opinion that I'm reading. Okay. Where is it similar? Where are they different? And, what are unknowns? So, there might be something in a client's case that we don't have as part of ours. I mean, in a written opinion that we don't have in our own personal case, or there's something in our own personal case that isn't mentioned in the published decision. So that's just kind of a way to talk about facts when we are either in our own cases, in our own client files, or in the cases that we're reading. And why do we give a crap about facts in the first place? If for a case that I'm reading to apply to my client's case, the facts have to be similar, right? That's part of that chart. And if they apply, if they're similar enough, they apply. If they're different, the case won't apply. Laws themselves. So we just think of negligence, and there has to be a duty, a breach of duty. There have to be injuries, and then or damages of some sort, and the breach of the duty has to approximately cause the injuries. Okay, so that's the law. But without our factual situation, who cares? You can't talk about the law in a vacuum. What what was the breach of the duty? What was proximate cause? So judges interpret these legal rules like the elements of negligence by applying them to the facts that they're looking at. So we have to really, before we do anything, figure out what the facts are. Okay, so our facts is what happened, right? Information concerning a person, thing, or occurrence. Our rule of law is this pronouncement that establishes a standard of conduct. What is negligence? What is the definition of assault? What is the requirements of driving under the influence? So that's our law. And then we have our law, and then we have what happened, right? This guy was speeding and his blood alcohol level was whatever, 0.9. So those are our facts. We apply them to the rule of law. Okay, are all those elements satisfied? And if yes, then they have violated that law. Okay, so we're applying our facts to the rule, and that gives us the conclusion of law. Okay, and that was when the court determines whether the specific rules of law apply to a set of facts and how. That's on Statsky, page 73. Okay, and the conclusion of law in a case opinion and a court opinion that we're reading is called the holding. Okay, so here we have an example, Illinois assault law. Okay, these are a person commits an assault when, without lawful authority, and they get there. Okay, so I'm going to put this into kind of elements, right? So one is they don't have lawful authority to do it. They knowingly engage in conduct which places another in reasonable apprehension of receiving a battery. A battery is so an assault is not a touching. Battery is a touching. So here we have somebody comes into a convenience store and says, I'm going to shoot you unless you all get down, or like get down on the ground right now. Okay. So, and he has a gun. Okay. So if this is just random robber, right, he would then not have lawful authority. And he's saying it out loud. So he is knowingly engaging, and him having a gun sounds like that would be reasonable apprehension of receiving a battery or getting hurt by being shot. Now, what if the facts change? The guy comes in with a police uniform or a badge and says, "Get on the floor right now." Okay, so what's in this situation? Still has his gun. He has lawful authority, presumably, or we have to figure out if he did have lawful authority, was whether he was a real officer of the law. So you see the facts change. As the facts change, the application of the law changes. Okay, see, here we go. Or without lawful authority, knowingly, reasonable apprehension of receiving a battery. Okay, so things that would be our key facts, these relevant facts, these essential facts, was the person who was saying, "Get down on the floor now," waving a gun, was that person a law enforcement officer who, at that point, maybe he was doing that because there's danger outside, somebody's shooting, or there is someone robbing the convenience store and he needs everybody on the floor to determine what's going on. Okay, so that's a key fact. Was this person, was it lawful authority? Now, if he comes in waving a plastic blow up baseball bat, screaming, "Get down on the floor," is that reasonable apprehension of a battery? No, right? So those are our key facts. If the facts were different, the ruling of the court would be different. Okay, so I guess this is in Statsky. When you're reading a case, you want to figure out maybe which ones are really the key facts, and things that you would figure out, ways you would figure it out if they were key facts would be, does this court discuss this fact as a part of the reason for their holding? So when they're doing their analysis section or their discussion section of their court opinion, do they talk about that fact? When they're writing out their facts and the opinion, how do they characterize this fact? I say that, he, as a lunatic would do, right? That would be a characterization. Do they talk about the fact that a party had mentioned in their brief? We'll talk about shepherdizing on another day because we haven't talked about that yet. Discussion of opinions, so discussion of other opinions that they're talking about inside this case. Repetition or things like that, or other things that they might talk about. Shepherdizing, which we will talk about in like a month maybe. Shepherds is a tool that we use to find similar cases and to determine whether our cases are still law. So you might be, when you're looking at a Shepherd's report, you might be pulling up cases with similar facts. So that's what shepherdizing has to be. It is unlikely when you're performing legal research that you'll find a case with the exact same facts, because if there were the exact same facts, maybe it wouldn't have gotten to the point where you're in court, because the law, you might have had a motion to dismiss because the law is exactly the same. So when you're doing your legal research, you're looking for cases that are similar or analogous, and you want to find cases where your facts, there's sufficient similarity of your client's case to the key facts in the court's opinion. Okay, so back to Hamies. So things that facts do, they give you the legal label that you're in. Okay, is it a criminal case? Is it a tort case? Is it negligence? Is it an intentional infliction of emotional distress? So based on the facts, you have to figure out what legal labels you're going to put on it. Okay, and then when you're, after you've done your facts, you have to figure out the questions that the court is answering in the opinion. And this is all part of your homework. You're going to be writing issue statements. If the facts are such and such, what are the legal issues? What are the legal consequences? Okay. Sometimes when you're reading an opinion, they will call that questions presented. Or when you're writing a brief or an appellate brief, you might say, these are the questions presented, the statement of the legal issues presented to the court for resolution. Okay. So if you want to figure out how to write a legal issue when you're briefing a case or you're writing a memo, look on the bottom of page 25 in Hamey's. 25. Here we go. Oh, let me go here briefly. We're kind of done with our facts, and now we're on like the legal issues part. So legal issues are important because until you have you know what your facts, what legal consequences your facts present, then you can figure out how to proceed in a litigation. Okay, so litigation, the first pleading, which is the document filed with the court in a case in litigation. Okay, so the first pleading filed is called a complaint. Okay, so the complaint is where the plaintiff names who the defendants are in the case, who they are suing, and they have to allege in this complaint a basis that they can recover. Okay, and you can't just recover because, oh, someone looked at me with the evil eye and that hurt my feelings, right? That is not a valid, what we call cause of action, a legal basis upon which a lawsuit may be brought. Okay, so there's bunches of bases for causes of action. If you've taken torts, you'll know, like, you know, it can be, you can bring something on negligence, you can bring something strict liability, you can bring something for defamation, you can bring something for libel, you can bring something for breach of contract, all sorts of different bases upon which a lawsuit may be brought to court. And when you're filing your pleading, your complaint, you have to set forth all of the elements that satisfy this cause of action. What are the requirements to recover? What number of things need to be satisfied before you win your case? Okay, and those are called the elements. Okay, like steps. This has to be satisfied, this has to be satisfied, this has to be satisfied. Back to, where we had the assault. If I am a state's attorney bringing a cause of action against a defendant on the basis of assault, I have to plead why, the facts that say they were doing this without lawful authority, that it was knowingly, and then there was a reasonable apprehension of receiving a battery. So I have to allege facts sufficient to state that cause of action. Okay, and then so say, all right, the plaintiff filed a case against me, the state's attorney filed a case against me for assault, then I have affirmative defenses. So those are defenses raised by me when I'm answering. This is the next pleading. So you have the complaint and then you have the answer. The defendant files an answer to those allegations in the complaint. So why the plaintiff shouldn't recover even if all the allegations in the complaint are true. Okay, so it might be, if you're in a negligence case, the plaintiff was equally as negligent, or that I have tort immunity or something along those lines. So a reason why the plaintiff should not recover. Okay, so then we're facts, pleadings, and now we're on issues. Okay, so I was on my issue. Okay, so if I'm looking for, my issue, we have this case where somebody stole something, and if you're looking for the legal issue, you might say, did the defendant commit robbery? Okay, that's not good enough to write when you are writing a legal issue. Okay, your legal issue has to contain the legal conclusion, did they commit robbery? Right here, did the defendant commit robbery? Why? What did he do that may have constituted robbery? So this one, he pushed the victim to the ground, grabbed her purse, blah, blah, blah. Okay. So our issues have to have two elements, legal and factual. And this is part of your homework. So please remember this. Okay. So did they commit robbery when they did these things? Or, you know, even if it's one element that you're trying to determine here, did he commit robbery? Was it a felonious taking? Was it a felonious taking when, he was taking something from the house that he owned prior or something like that? So your legal issues have two elements. Okay, so here it is. Did the defendant commit robbery? Okay, you have to have your legal conclusion along with the facts that can be applied to the conclusion. What did the party do that might constitute robbery? Oh, look at my spelling. Pushed, grabbed, the victim yelling, right? So those are all things that put it to being a robbery. Okay, so let's just some other examples of writing a legal issue here. Okay, so a driver runs a stop sign and injures the pedestrian. Okay, is there a negligence claim, right? Is this negligence when a driver runs a stop sign and injures a pedestrian, right? We're putting the legal conclusion and the facts. Customer falls on a wet floor after it's mopped when they see that there is a wet sign is visible, right? So negligence has a duty, a breach of duty. And so this would be on the duties thing. Did a store owner breach their duty when there's a wet floor, even though they had a caution wet floor sign? Okay, that's kind of your issue there. Property owner fails to replace rotten steps. Okay, did they have a legal duty to replace rotten steps when they had visiting guests? Shoveling the sidewalk and pedestrian. Does a homeowner have a legal duty to shovel their sidewalk? So those are kind of your legal issue examples. Okay, so in Kylo, you can look in there, back, next page here. Okay, all right, so elements, we talked about elements, right? Negligence has 4 elements: duty, breach of duty, causation, and damages. So we don't just say, were they negligent? We kind of say, did they breach their duty? Sometimes the issue is, was there a duty? Sometimes the issue is, was there a breach of duty? And did the actions cause, and were there damages? Okay, so say on the shoveling the sidewalk, does someone have a duty to shovel their sidewalk? I don't know. Did they breach their duty even though they had a sign that said wet floor? Causation and damages, like, if I looked at you funny, but, nothing happens, were there damages? Probably not. So elements are the components of the cause of action. So here's my elements for negligence, and we have to allege facts that satisfy each of those elements to allege what we call as a prima facie case on its face, on the viewer or on its face, that we have stated a cause of action in our complaint. Okay. So here's our facts. Oh, look, I've done some highlighting. That's fun. So our facts and issues gives you really a lot of help here. The case presents the question whether the use of a thermal imaging device constitutes a search. So if you're writing this out, can I copy it? Oh, I can. Okay, I'm going to wait. Copy. And okay. I'm going to open up a Word document. Okay. And then I paste it. So, I would like to confirm that I want to copy this. there it goes. Okay, so this is, remember, questions presented. We want to turn this into an issue question. Okay, so it's not just, don't just put whether. Get rid of this, and we just put does the use of a thermal imaging device aimed at a private home constitute a search within the meaning of the Fourth Amendment. Okay, so that's how we change that questions presented section into the legal issue when I'm trying to brief this case. Okay, I'm going to close that. Here's my facts. So I want you to go through this, and then I want you to go through like the facts and figure what you think. Sort them out. What are my, my key facts, my relevant facts? What are explanatory facts, and what are kind of unnecessary or irrelevant facts? Okay, and then here is where they're applying the facts to the law. Okay, so this is an example: eavesdropping by an electronic listening, and whether that was it. And I'll just go through and take 3 or 4 minutes to see how they use facts and apply them to the issues, because that'll be very helpful for you in the future. Okay, let's see what else. Okay, Kylo, we did that. The Baylor example on page 28, it's something that you'll probably get in your career. You have a bunch of, from like page 30, 31, you have a bunch of documents that you're getting from a client or from a case file. And you have to, from there, pull out what are the facts that are important, and then maybe start thinking about the legal issues involved. And then, so I do want you to take a few minutes to look through that as well, and pull out what you think might be the key facts, and what are then, from where that comes from, what will be our legal issues. And, as a paralegal, you might be doing a lot of summarization of documents and indexing of documents, so that when the attorney goes in later, they can jump right to the point of the document where this is stated or where this is important. So, as a time-saving feature for the attorney and in the future of the case. Okay, well, this is a little bit out of order, but remember our pleadings. First, we have our complaint. You have to state a cause of action, and you have all your elements. You have to state facts sufficient to state this cause of action. The answer is the response, where you either admit or deny the allegations, and you might have, after the responses, you might have an affirmative defense. And a motion is the written request. It's a pleading. You're asking the court to do something. I want a motion to dismiss. I want a motion for an extension of time. It's a written request to the court for some sort of relief once you're in a lawsuit. Our cause of action is our legal basis for the lawsuit. Is it a cause of action based in negligence? Is it a cause of action based in a particular statute? Is it a cause of action based in contracts? What is our legal basis for the lawsuit? Okay, so when you're reading a case, and this is again for the homework, this will be helpful for you. How do we find the issues when we're looking at a case? So they do help you out a little bit. They give you language. A lot of times the court gives you language. Like, sometimes it's super easy. The issue is, before the court is, the appellant claims, and then the other trick is to go to the end of the case and see what conclusions, what holdings the court have made. Okay, a holding backward is an issue, just like addition backwards is subtraction. So those are just kind of look for those little keywords to find your issues. When you're writing legal issues, and again, this is important for the homework, make it a question. Don't just put whether in front of it and think that's a question. That's not a question. Okay, look to the cause of action. What are the elements? Do you have for our which element may not be satisfied here? Has this basic requirement for this cause of action been established, the minimum requirements. And then in court opinions, which kind of goes back to the beginning, when the courts are making their rulings, they need to see whether the cases cited are, cited as precedent, where they apply, and look to that Kylo case as an example of that. They want to make sure that the key facts are similar enough for that rule of law to apply. And you must be able to show that the key facts of the written opinion and the client's case are sufficiently similar to make sure that they apply. Okay, so when you're doing your research, you're looking at cases. What are the similar facts? What are the difference in facts? Are there fact gaps? Just like that chart we looked at in the beginning of the lecture, and then Statsky has that again on page 143. When you're writing, if you're writing to the court and you want to persuade the court either that a case should apply or should not, if you want the case to apply, argue that the facts are similar. You acknowledge differences in the facts, but then argue that they're not key facts. Same thing for fact gaps. And if you don't want the holding to apply, do the opposite. When you are citing to cases, don't do what we call crane analysis, like a crane that you pull something up and move it from one place to another. Don't just lift language or direct quotes from an opinion and shove it in your legal writing. That's bad analysis. And don't just take, I like the way that quote sounds. Don't use a quote out of context. Don't regurgitate. Make sure you're actually digesting what the material means and not just vomiting it up. Okay, so these are just some important terms that we talked about, right? What's a case? What's a decision and opinion? Primary authority, okay? Resources that give you the actual law. What's a cause of action? What a basis on which you can file a complaint? Pleadings, different pleadings that we talked about, like the complaint, the answer, and a motion. Prima facie case, on its face. Am I stating enough that if I proved all of those facts, I would win? Okay, elements. Okay, any cause of action is usually not just one thing. One thing has to be satisfied. There are a number of things that have to be satisfied for us to succeed on that legal theory. Judicial history. I didn't really talk about that. I kind of skipped through. Let me go back and I'll show you. Okay. Boom. When you're looking at the facts, sometimes there's kind of two different sets of facts that they talk about. One are the facts of what happened, and then the other part would be the judicial history. So sometimes the facts of the case are not even the case that's being discussed aren't really related to the underlying actual situation. It's kind of the issue comes from procedure, how this case got where it is. Here it is. What chapter am I? Oh no, not this one. How did I get here? Maybe if I look at the book here, I'll find it better. But it's on page 25. Okay, let me get there. Okay. So sometimes it's like, was this motion proper? Did they make an error in denying a motion or something like that? Sometimes was the evidence properly included? So when you're doing your facts, when you're doing your case briefing, and we'll start more about case briefing next week, the judicial history, how we got here, is really important to look at and to discuss as part of your case brief. Okay, so that's the judicial history. All right, and that's kind of it for this part of our lecture. Takeaways that are really important are what are the different kinds of facts and why are they important? What is an element? What are the elements? You don't have to know what the elements are for each particular cause of action, but you have to know what elements are. And you have to know about writing legal issues. So that's what your homework is going to be. Your homework is going to be where the next thing you're going to do is watch the Blue Book video and look at that PowerPoint and practice your Blue Book. So that's part of your homework, is finding, pulling up cases and Blue Booking them. But then the second part is I'm going to give you a case, and then you're going to write out the facts. Don't give me, bullet points. Like, write it out as a paragraph, your facts, and then write out the legal issues. And remember, the legal issues need to be in the form of a question, and you have to have a legal component, and you have to have a factual component to it. Okay, so that's it. And good luck on your homework and your quiz, and I will be chatting with you next week.